Hi, everyone. Nick Chavez here, Chavez Valko, your key to immigration solutions. I'm here with my law partner, Martin Valko. How are you doing, Martin?
Doing well, Nick. Doing well. Thanks for hosting today. It's an exciting day, exciting week, exciting month.
Yep, yep. Um, yeah, we're here to just give you the breakdown and give you any updates if we have any, but more importantly, to answer any questions you might have. To discuss this new parole program, right, for mixed status family members. As a reminder, this new policy was announced over a week ago. And so we'll go over some of your questions, some of the questions that have been raised by our clients. You guys, through messages, we've been receiving some really good questions about this new parole initiative or program. So if you have any questions about this program, if you're curious to see if you would qualify, please let us know. Send them to us, and we'll be happy to answer them. We'll try to answer them. But before we begin, we ask that you please subscribe to our channel and hit like. You know, we're on our way to 5,000 followers on our YouTube, and we certainly appreciate your support and are very grateful to our followers, right? You know, we enjoy doing this thing. We're immigration lawyers, and we have to follow these developments, you know, for you and our clients, so that you're kept informed and educated about the news. But not only that, we enjoy breaking down the law for you. We try to, you know, try and simplify it, and because let's be honest, immigration law is very complex, and we're glad that we can help explain the process to you. So thank you for following us. So real quickly, you know, this new program is known as Parole-in-Place, or PIP for short, and the aim is to help those immigrants that are married to U.S. citizens who are living here and cannot get a green card directly with USCIS because they had entered without inspection or without an entry document or permission. And for those who want to apply for a green card here, that process is known as adjustment of status. So if you're on your computer and you're typing away, you know, adjustment of status, that is the process to do it here, as opposed to doing it outside, which is known as consular process. Consular because at the trail end, you have an interview with the consulate office at the U.S. Embassy. But the main requirement for eligibility to do it here is to show that you have entered with permission. You know, the law says to be able to apply here, the person must have been admitted or paroled. So that's why this program is referred to as parole. And it sounds, you know, really bad because it's a term that we often use in our criminal justice system as part of a sentence, right? We're describing a sentence, you know, parole. But here, for immigration purposes, it's a good thing. It's essentially what it is an entry document that would meet the requirement to apply for your green card here, but you are already here. You entered already. So how would you use it as an entry document? Well, that's why they call it parole-in-place, meaning you're here in the United States. You wouldn't use it as an entry document, but it's used instead to provide you some sort of temporary status, and why allowing you to meet that requirement that you were admitted or paroled for purposes of adjustment of status. How do you like that explanation? I mean, you got to have your head in the blender to explain those kind of things, right? They're pretty strange, but that's why they say the immigration law is so darn complex. So the other thing that I should bring up is that you know, we will try to answer your questions, but there are some questions that we don't have clear answers for at this time. You know, this is because USCIS is supposed to provide us with additional guidance or information about who qualifies, right? How to file, what to include, where, how much the fee is, all those details. You know, they're forthcoming. But you know, we'll share our impressions. Marty and I will share our thoughts while we wait for USCIS to publish this information through the Federal Register, which could be anytime this summer, hopefully. Which brings me to another point. Some of my clients, and Martin, you've been speaking with clients as well. You know, they're talking about this. We're excited, but we've had individuals who are saying that, you know, they're receiving calls from places about this process, that you know, these places, they already have the forms, they're filling out the forms, they're filing it, they're even hounding them for money. I had one client who said that there's a person, you know, calling them nonstop for $1,000 for them to file this application. And you
That's a
know,
deal. That's only $1,000. That's a deal.
and you know, it's really, you know, stop already. There are no forms yet. We don't know how much the fees are. There's no filing process yet. You know, if someone is telling you now that they know everything about the process, run for the hills. You know, avoid these places. And we've seen that, right, Martin, with DACA when they first announced that program. There was a lot of scams.
There's a lot of scams, but definitely just kind of keep it at bay. And if you have a trusted lawyer you've worked with, or you watch, you follow them, I would just make a consultation with them and just go over your questions, because everybody has questions, and our current clients have questions, and so we meet with them and try to explain to them the potential benefits from it if we're working, for example, in the consular case on the provisional waiver. And that definitely would be helpful. But certainly nothing's in place, and you know, what you could do is just answer or go over your typical process. I mean, something similar is already in place. Military parole-in-place has been around for about 11 years or so, close to 11 years.
Right.
And it's a DACA, you know, back from 2012. It's you have a time period, and you have to basically show. So going back to the requirements that people often ask about, you know, like, you know, make sure, or to be eligible, you have not been admitted or paroled into the U.S., as you mentioned. You have been physically present in the U.S. for 10 years, from June 17th of 2014 until the program was announced. So for 10 years. On June 17th of 2024, you were married to a U.S. citizen. And you know, other things like good moral character and otherwise being admissible. A lot of those things will get worked out and will get kind of filled in as they release it. So we don't have all of that, but we can make some assumptions, and we have a kind of a blueprint of the process, what it's likely to be like. So you know, when people ask, you know, what to do, what should I be looking at, and you know, look for evidence of physical presence for the last 10 years. Look at any documents you can find with your name on it that puts you in the United States, whether it's a you know, a phone bill, utility bills in general, bank statements. Some people, or I'd say a lot of people, file taxes under the IT numbers. Anything, you know. I mean, back then with even with DACA, I mean, we're looking at, in some instances, for photos that, I mean, social media has been just started being around and everybody had it, but you know, we had photos with the date, you know, the little date, month, date, and a year on the bottom of it. So it's a lot of things that you could be doing, and that's a good starting point.
Yeah, and you made an excellent point. Look, this is not a new program. A lot of people think that this is new, but it actually, Parole-in-Place exists already, right? In the context of, well, there's a military Parole-in-Place program for individuals who entered illegally and are married to U.S. citizens, but they have family members that are in the U.S. military. They are currently active, or they were honorably discharged, and they would allow, you know, they're allowing them to apply for this parole, and that would allow them then to proceed on to step 2 if they're approved to apply for their green card. Just real quick, just to get some shout outs here. We have Patricia Atiliano. Hi, Nick. How are you doing, Patricia? I think Patricia's from California. I want to say she's from California. I may be wrong though, but Emily, you know, thank you for your comment too. The DACA people who have a business but doesn't have a degree can have an advance. Let me see here. I think I'm reading it incorrectly here. So she's asking about people. You know, with this announcement about Parole-in-Place, there was like this little minor announcement having to do with those who have DACA. And if you can tell us a little bit about that, right? It almost was eclipsed because we were all happy about Parole-in-Place, and there's like a little shout out to DACA for those who may possibly apply for a worker visa. This is relief because DACA is not going to last forever, right? We kind of anticipate that next year, if it goes before SCOTUS, Supreme Court, it might not survive beyond that. And so they're looking at other options, and I wouldn't blame them. Could you explain a little bit about this new program that they announced?
So with this announcement about the Parole-in-Place for spouses of U.S. citizens was a little blimp about applying for work visas for people who are DACA recipients, as well as people who had graduated U.S. colleges. So I read the press release or the FAQ on the Department of State's website that alluded to it, and then the forthcoming regulations will be published in their online, or in the, we call it FAM, which is the Department of State regulations, and basically what happens is if a person entered unlawfully, for example, like a DACA recipient, and they've applied for DACA. Often we see people that have been granted DACA beyond their age 18 and 6 months, or they have accrued unlawful presence. So they were present in the U.S. without any kind of protection, without status beyond the 18th birthday, or DACA is not status, but it's an authorized stay, so it protects them. Or sometimes they skipped between the validity between the expiration of DACA and when the new DACA was announced, and that time adds up cumulatively. And so whenever a person has over the age of 18 has more than 6 months of unlawful presence, they are inadmissible. And so DACA, I mean, I call it it's a Band-Aid of sorts, which allows person to be here. And since 2012, for the last 12 years, people were able to renew their DACA every 2 years, but they're stuck here. Right. And so there are two ways to travel outside. So if they have DACA, they can apply. And that's what she actually mentioned, DACA advanced parole. So, I mean, it's a little bit off topic, but DACA advanced parole, even if the person is basically a sole proprietor or owns a business, they should be able to, based on employment basis, because there are three bases you can apply for DACA advanced parole, and that's humanitarian, educational, or employment. And we've done plenty of DACA advanced paroles in all three categories. And so, to answer her question, as self-employed, could she apply for DACA advanced parole? And I would say yes. Obviously, it has to be a well presented case, and the adjudicator will make a decision if the parole would be approved, and then the person would travel, this particular viewer, and be paroled back into the U.S. Now, the question is, what could you do with that parole, right? Obviously, if you are married to a U.S. citizen, that opens up a way to adjustment to a green card. And that's basically what we're talking about here today. And so in Biden's proposal, basically it is allowing, and he's asking Department of State to issue guidance on how to speed up processing of certain non-immigrant or a certain non-immigrant visa waiver. It's called under Section 212 D3. We refer to it as a D3 waiver, because again, if you have somebody who is a DACA recipient, or somebody who graduated college, as Department of State indicated, and they get sponsored by an employer, right? So DACA recipients, they have work authorization, but somebody else who doesn't have DACA gets sponsored, for example, gets sponsored for an H-1B, they get picked up in the lottery, but they cannot change status because they have no status. And so they have to leave the US and they have to apply for the H-1B visa or a TN visa for Mexican national, for example. And the minute they leave the US, they trigger that inadmissibility bar for 3 or 10 years. And so while they can apply for the visa, they're inadmissible, so the visa would not be issued. And then there are a couple of steps. So they have to be eligible for the visa. So if your H-1B petition was approved, you are eligible. Then the consular officer has to recommend the issuance of the waiver. right? And again, this is a waiver you're asking under Section D3. There's a common case that lists out the eligibility requirements. It's under matter of Franca, and you basically list out, why you're admissible and then how you can overcome it. Basically, you're just weighing factors, and so the officer has to recommend the waiver. And if they recommend it, they'll send it to the Customs and Border Protection, which is part of the Department of Homeland Security, to their admissibility review office, and they have to make a determination whether that individual should be granted the waiver so they can come back into the U.S. and then get into status. So they're waiving that unlawful presence. And the problem there is that currently it's taking about 5 to 6 months when you are outside of the U.S. and you're waiting for this waiver to be reviewed and granted. And at first, when I read it, I thought, man, Nick, this is incredible. This is going to be something similar to provisional waivers, right? So you don't go outside and apply for the waiver like we've used to do that before 2013. You apply stateside. You wait for the decision, and if it's approved, you go. So everybody thought, that I spoke with, and even within the office, we thought stateside waiver. So person is eligible for H-1B. They get selected. They applied here. Department of State adjudicates, or the CBP adjudicates that waiver. And if granted, you'll go outside, apply for the visa, get the waiver, and come back, right? And the FAQ from the Department of State says, no. We're looking into expediting the process. Now, Department of State has nothing to do with the ARO's decision. It's just kind of moving it faster along the way at the consulate. So, DACA, the question was about DACA AP, and I'd say, yes, she might be eligible. And then this little blip that was just mentioned, I think it'll be a great thing. It's somehow they can really expedite it, because, I mean, if you are self-employed, if you're being sponsored, an employer needs you to come back. You can't be waiting for 5 or 6 years. I mean, 5 or 6 months, and then potentially not be able to come back. So they got to list out factors. What are the eligibility requirements? And then the applicant and the employer will determine, hopefully with an attorney, is this worth going? Is this a provable case? Will the waiver be granted? So that's basically what it is.
Yeah. So we're getting comments from Instagram, and there are individuals, we get comments from our current clients, from people who watches, and we do have cases right now that are in process, and they want to know, what should we do with our application? Because the whole goal of this, right, is to avoid having to go to Ciudad Juarez or whatever outside, and allow them to do it here. And it depends on what the case is. So really, I hate to say, we got to, sit down and talk about it, but that's the reality, because each case is different. There are some cases where I'm going to tell my clients, you know what, I think we go ahead and proceed, based on the facts. I think this is a good chance. If you want to get your green card, if you have your visa interview, next month, this is your chance to do it. And I weigh that with, with the fact that this is a new announcement. Is it secure? We don't know, right? Because this policy, we love it, right? If it goes through, it will allow individuals to not take the risk outside, right? We don't want to take the risk, but in reality, we don't know if this is actually going to go through because of litigation, right? You see people, the red states, including Texas, they're gearing up for litigation. They want to block this. And, honestly, if we have a change in administration, what's to say that this new administration, which has proven to be anti-immigration, might pull the plug on that. So there's a lot of uncertainties. This is great news, but to me, I want to see the process. I want to see the process operating. Okay, I want to see people. I want to see USCIS taking in those applications and processing them. That will provide more confidence, right? Otherwise, I'm thinking that it might be a good idea to move forward. Now, there are some cases where, it would be a good idea to wait, because perhaps, our clients may have a criminal background, or an officer might think that this person is problematic based on his history, or there's some questions. On those types of cases, I think that it might be worthwhile, sitting down. So I ask my clients to be patient. We're trying to get through and talk to all of our clients that are in this situation and have that one-on-one. Don't feel like you are rushed to do things right now. There's not even a filing procedure laid out yet. We don't know what that is. We don't know what the forms look like. And like I said, there's a lot of these built-in uncertainties with this Parole-in-Place program. So I think that it's worthwhile to sit down and just really weigh it out. But it doesn't necessarily mean that you will then just drop your case and then not move forward with it. Like I said, there are certain cases that I think, yeah, well, let's move forward. Let's do it. What are your thoughts on that, Mark?
No, I mean, we just talked about it. It's and we see it daily with consultations where people are desperate. They've been waiting for years and years and years, and something positive every once in a while comes across, and their hopes gets up, and then you get something like this where you actually get the president get on TV and said, "I'm doing this," and people go like, "Holy crap, it's happening!" Right? So that's where these mooches, these people just jump on and they start leeching off and they start deceiving people. And again, you are desperate. I mean, we all at a certain point have been gotten taken for something, right? And it's like, because you try to focus and try to be precise, and then boom, somebody calls you and or sends you an email and said, "Hey, this is something new. It's ready. Come on, let's pay me money, and let's do it."
Yeah. Moving on, we got a question here from Amalio Guevara. Amalio, hello, thank you for joining us. And here, saludos from Washington State. Wow, that's I'm pretty sure it's below 60 degrees, maybe 70 degrees. I don't know. It's humid here in Texas, but he has DACA and he's married. He wants to know if she can come visit in the United States. So congratulations on being married, but this person is not from the U.S. citizen, so you wouldn't not be able to benefit from this new announcement, because for this new announcement, you have to show that you, as of June 17th, 2024, you are married to a U.S. citizen. But here you're asking something different. Can she come and visit? Is that something that, of course, I mean, short answer, yeah, sure. I mean, they just have to meet the basic requirements to apply for a tourist visa, which are, that this person has a residence outside, that has to have a passport, and has to have an interview with the U.S. consulate. Is it okay to say I'm visiting Amalio because he cooks really good Mexican food? I mean, of course, you could say that. You have to be honest and say, look, I'm going to go and visit with some friends. And, it's still a 50-50 shot when we're talking about applications for a tourist visa, but she can certainly do that. Moving on and staying on topic and not talking about, digressing about Mexican food, because I'm getting hungry with that. We talked about the main requirements, but there's also a chance for some of our clients, some of these individuals that could benefit from Parole-in-Place they have children with them and maybe perhaps stepchildren, right? And what can they apply for Parole-in-Place along with the parent? And the short answer that immigration gave us is, yeah, I mean, it's just as long as they meet the requirements. But there are additional requirements for those who are stepchildren, right? They have to show that the biological parent and the step parent got married before the child turned 18 in order to meet that definition of child, but it is possible. This is a very common question, and this is why we posted it, because this is like every day we're getting the question about common law marriage. I had an individual I spoke with. She told me that when it was announced that, she looked over to her common law spouse. I think that they're married, but she looked over. They looked at each other and they said, "You know what? We're not married." And so they decided to make an appointment with the county to get married. And they saw a big line because I guess everybody heard about this, and so everyone rushed to get married. But then I told her, you live in Texas. Texas recognizes common law marriage. To meet that requirement that you were married as of June 17th, if Texas recognizes, or the state that you live in, if they recognize common law marriage, you don't have to show that you have a marriage license. You just have to show that you meet the requirements of a common law marriage, which a common law marriage means it's a legal recognition of a couple, a married couple, that they're married without a license. And in Texas, you have to show three things. You have to show that you agreed to get married. You have to say, hey, look, we're going to get married, right? Yeah. After that agreement, you have to show that you live together, that you cohabitated here in Texas. And the most important one is that the third requirement for common law marriage here in Texas is you have to show that you are representing to other parties. And then one of the ways you can do that is if you put on your taxes, if you've been claiming taxes as or filing taxes together as a married couple, then that is a representation, and you could meet those requirements. But I would caution, I would say that there are people from Washington State that are listening to us, and each state is different. They may not recognize common law marriage. So it's important to consult with a lawyer to see if you meet the specific requirements, because those vary from state to state. What do you think about this, Martin? This is a very common question that's been raised about the permanent bar. If you could explain a little bit what the permanent bar means. That we have people that say, I've been here in the United States for a while, and then I was here for a year, and then I had to go back to my country, and then I came back, and they're saying that I can't get my green card because I had multiple entries. What is that all about?
Yeah, real quick on the Washington State, no comma. It's not a common law marriage state, according to my quick search online. So Washington State does not recognize informal or common law marriage. The permanent bar, right? So often we refer to it as perm bar or death penalty sometimes in some cases. So a law has changed, and starting April 1st of 1997, if a person has been in the U.S. without status unlawfully for more than a year, and that's cumulative. So you could make several trips and it adds up. You could even be here illegally with a tourist visa and overstay and start adding up over 12 months of the period. And then the last time you try to come in, you enter without inspection, without a visa. And that happens. People get their visas canceled. And so when you've been to the United States unlawfully for more than a year, you leave, or you have been removed from the U.S. Under Section 235B1, which is an expedited removal order, and you leave and come back into the U.S., or a removal order, and you come back without inspection into the United States, you are inadmissible for a period of 10 years. There are some certain exceptions in certain types of cases, but overall, for example, for somebody who we see people like that come in and they are subject to 212A9C, the permanent bar, and they were married to a U.S. citizen on June 17, 2024. They've been here for 10 years, but they're subject to the permanent bar. And so, if they get parole, could they go to the next step, the step number 2, which is the adjustment of status, which is the green card application? And the answer is no. And so it seems like, and that's what I've been hearing, that if you are not eligible for step number 2 for adjustment, you may not be granted the parole-in-place. Now, it'd be nice if they granted it anyways, so the person's could have parole for 3 years and apply for the work authorization document. With that, you can apply for driver's license, et cetera, et cetera. But again, this is something that hasn't been released yet, and that information will be forthcoming. But that's what permanent bar is. And then again, when I go back to the beginning, when you said, we would prefer to apply for a green card in the U.S. as opposed to going to the consulate, because you could have everything could be working out, right? You have your provisional order approved, but you go outside and there are some questions about your prior entries, and if they add up to a year. And sometimes people are unable to document it, right? Sometimes they're unable to show that, they're not subject to the perm bar. In cases where the clients or applicants want to go, they could get stuck. And so to avoid that, that finding, being paroled and being eligible for adjustment, if they are in fact eligible, is the way to go.
Yeah. Thank you for that. Here we have a question from Keith Matthews. So at the age of 18, he was lawfully paroled on a visiting visa in another name. Okay, so if Keith, if I'm understanding correctly your question, you want to know if you are eligible under this new parole process. It applies for those individuals who had entered without permission. Okay, meaning they entered here, they weren't inspected, and they weren't given a parole document, because parole is essentially it's an entry document. So if you were paroled or if you entered on a visitor visa, unfortunately, you would not be eligible for this new program, and we would have to look for other options.
But if I may comment on Keith's question, if you were inspected and admitted, albeit under a different name, and it just depends what you used, then you were inspected and paroled. Now, it really depends. We've had cases where persons had used somebody else's passport. They were admitted and inspected and admitted into the U.S. They were married to a U.S. citizen, and they applied for adjustment of status. They were inadmissible under for finding of under ground of inadmissibility for fraud or misrepresentation, but they were eligible for an inadmissibility waiver, which they had to prove that the U.S. citizen spouse would have suffered extreme hardship in certain circumstances. And I can say that we've had cases like that successfully approved, but every case is different. So while, as Nick mentioned, this particular parole requires that you were not paroled or inspected, you may have a way anyways if you're married to a U.S. citizen and it's a bona fide marriage and there's extreme hardship for the waiver. Yeah.
So this is good news for people who entered without permission, but if you entered with a tourist visa, that's good news too. So if you're married to a U.S. citizen, you don't need this parole in place. You don't have to go through these hoops. So yeah, but I would recommend that you consult with an immigration lawyer and discuss your case more in depth, Keith. Thank you for your question. Moving on, let's see here. We have a question from So H. Thank you for your question. It says, hello, I would like to learn about what happened to the accrued unlawful presence for DACA. And this is really about that announcement, that side announcement about DACA and how they're trying to apply this new policy for those who are wanting another option. Right? DACA is not going to be around forever, so there are people looking to see if they can swing to another status or worker visa. And normally for a worker visa, you have to, if you have not been here in the United States lawfully, then you would have to go outside to get your worker visa. And that's the problem, right? Because the moment you step outside, you can trigger this bar based on the time that you've been here. But that's something that we have to determine. It turns out that some people are not even subject to the bar because it never was accrued. But that's the reason why people are talking about, man, if I have to go outside the country and to apply for this worker visa, and if I'm going to be subject to this bar, that's just not going to, it's going to be too risky. So that's why they're talking about allowing you to do that risky part here in the United States, which is the waiver, before you apply. But there's still, when they announced it, it was very general. We're still waiting for more information. Obviously, I'm going to say, SOH, to wait for additional details because this could be beneficial. Martin?
Yeah, no, I'm just saying that we thought that the waiver is going to be stateside, and we're still hoping. But according to the Department of State's notes, it appears that it's still going to have to go through the regular procedure. The person will have to leave and apply for the visa abroad. It's just that waiver, the D3 waiver application process that's supposed to waive the unlawful presence, is going to be streamlined, and there will be factors posted. So, and this is the thing, what I wanted to point out. So when we deal with, for example, investors that have developed their business into multi-million-dollar enterprise, they employ tens, hundreds of people, chances of them, when they ask that they are here unlawfully, they are thinking about applying for the investor's visa, what are the chances of getting that waiver approved? And those chances are really good. If I have to say, with prospective clients that I've consulted with that are here in the U.S., nobody's willing to go outside and take that risk because they can't stay away for 5 or 6 months to wait for the waiver. But for those clients that we've worked that called us from outside, that they weren't our clients previously, and they got stuck and they said, "Hey, I traveled and I realized I couldn't come back." When they were these kind of people, these kind of investors, they got the waiver. I think we're 100% approval rate on those cases. Now, when you flip it to being an employee without this Biden push and Department of State push, it's like this weighing, like, yeah, but you are just, you're a DACA recipient, or you're just an employee, not an employer and job creator, right? So if they make it, if they streamline it, if somehow they'll weigh the benefits and weigh the factors, it's going to be beneficial for the DACA recipients and graduates of college and universities, right? Because that's also important here. Not just DACA recipients, they also say graduates of U.S. colleges. They say colleges. I thought they would put university as well. But anyway, so that could be your dreamers. When they say DACA recipients and dreamers, there you have it. So we're just waiting for more information to come up and see if it's going to be a stateside D3 waiver, or if it's going to be a waiver that's going to be streamlined, that you will be able to make that assessment before you go of what are your chances of receiving the waiver and coming and be able to come back safely.
Yeah. So stay tuned, SOH, and thank you for your question. Moving forward with some of the questions that we have been receiving. And one of them is, of course, can I apply now? And how much is the cost? And just to repeat, unfortunately, we can't do it now. We have to wait for immigration to give us the green light. And they still have to give us what the procedures are. So we don't know yet who, what, when, where. We don't have those questions yet answered. And we hope that sometime in the summer, they'll come out with additional guidance. Meanwhile, what you can do, as we've been saying, is that you can start seeing if you can collect some of that evidence that you can use if this goes through. And some of it is the evidence to show that you lived here in the United States for the last 10 years continuously. This could be income tax returns, bills, bank statements, credit card statements, the medical records, school records, whatever name, whatever document that contains your name and a date, that's something that potentially could be used. And then also, of course, your marriage certificate, and if you were married in the past, proof that that marriage was legally terminated, like a divorce decree or a death certificate. But again, we've been seeing people who say, I went to this place, man, and they're saying, hey, just $1,000 and we'll hook you up. Just give us your information and we'll start preparing everything. We'll be the first in line, right? And you just kind of have to be
ask
careful.
for the license they should ask for the license and insurance, like all of us attorneys have to go through.
Yeah. Also, be a smart consumer, right? Like when you go to, you're trying to get a product on Amazon, you're looking at the reviews, and same thing here, you go and look at the reviews, and you can actually go to the website. Each state has their state bar where you can look up the person and see if they've had any disciplinary action or anything like that. All right, so let's see here. We got another, it looks like we might, okay, thank you, SOH. Thank you for listening. Please make sure to subscribe. We appreciate that. We want to hit 5,000 followers on YouTube soon. So please, we appreciate that. We really do. All right, going on with some of the information that we get. So if I'm approved, right? If I'm approved, will I get my green card? That's another question, because they confused Parole-in-Place. Parole-in-Place is a way you can get your green card, but if you're approved, you don't get your green card. So it's like means to an end. What I mean by that is if you are approved, you're going to get a couple of things. You're going to, first of all, you're going to get this temporary protected status where they can't deport you. It's a shield, okay? but it will also give you the opportunity to apply for a work permit. So you have to do that separately. So you apply for your parole, and then you get the shield. And then once you get the shield, then you can, there's another step, and that's filing your application for your work permit. Also, if you're approved for parole in place, you would then meet that requirement, right? If you remember, to apply for your green card here, you have to show that you were admitted. And that's why a lot of people can't get their green card here, because they weren't admitted or paroled. That's the law. The law says admitted or paroled. And so if you get paroled, that gives you the possibility if you're eligible to then apply based on that petition that your spouse or your family member has filed to apply for your green card here through that process, adjustment of status. All right, moving forward, this is a question that we've seen already for the clients who are either in deportation proceedings, or they come to my office and they say, look, this is great news. The only thing is that, 10 years ago, I didn't show up to court, I have a deportation order. Is this parole in place? Is that going to be able to solve the problem?
Is that a question for me?
Well, let's just it's just going to throw it out there.
Yeah. So I think what the initial release mentioned is that if you're in removal proceedings currently, right, so it's ongoing, that you should be able to request the parole from USCIS, not even from ICE, Immigration and Customs Enforcement, but USCIS. But if you've been deported previously, then it goes back to the same question. Can you get to that end, right? Nick says the parole is a means to an end being the green card. Most likely not, right? So it depends on, am I eligible for a green card at the end? And if the answer is no, the indications are that you may not be granted parole. Like we said, we're hoping that that wouldn't be the fact, but we have to see if that's a possibility. Sometimes there is a chance to have that motion, that removal order reopened. So again, consult with an experienced immigration attorney to assess those options to see if that's a possibility. Because if somehow there is a chance of reopening it and you are granted a parole, then you may be able to adjust your status to apply to obtain your green card.
All right. And there's a case, there's a question I know somewhere around here, and I saw it, but I'll go ahead, and it really involves a person who has a DWI offense. Is that person eligible? And again, the requirements is to show that they're not, that they haven't committed they don't have this is the term they use, disqualifying criminal record. So what does that mean? We don't know yet. The DWIs could be, but we're waiting for additional guidance, and that's something that you should already have, ready to ask an attorney once we have more information. But certainly it could be considered as a matter of discretion, as far as we know. Folks, I think that's it. Let's see. We just make sure we're again. These are some of these common questions, right? And we're waiting for additional information. And once that information is out, we'll go ahead and send that information your way. We'll have shows, and you'll be able to ask your questions. We'll keep doing this, but in order to have to receive notices of these news, I think it's important that you stay on top. And one way you can do that is by subscribing to our channel, and we'll go ahead and send that information to you. I think it's important too that you get in contact with a good immigration lawyer. Like we're here too as well. But we realize that we're not the only immigration lawyers. There's a lot of good immigration lawyers. Get someone that you can trust, or a accredited legal representative, and ask your questions. It might be a situation where the first consultation, and I don't know, Martin, but for me, it seems like the first wave of consultations you know, there's still a little bit of uncertainty. I mean, we didn't get any aha moments. There wasn't anything like that. We still have to wait for further information. And I guess that's it. Anything you want to add, Martin?
No, that's it. You said it well, and we're here for you. Just to like and subscribe so you can follow us, and we'll be here to inform you. Other than that, just stay tuned. We'll be back soon.
Thank you, guys.